I mean, yes, I think so. I mean, that's why I say it should be treated as a public hazard resource, because it's related to another trust resource, and it presents dangers in different ways. That's an idea that, you know, the courts haven't touched it yet. I haven't heard it very many places, and I haven't written it down in an article, but it just makes sense. And several people during the conference have made the same argument that you've made. Yeah.
So I'd like to explore a little bit strategy and mechanics of bringing these cases. Like most folks in the room, I read about it. I'm from Boulder, Colorado. That's the high school kids I think you signed on in Boulder. So what students make your ideal plaintiffs? And so let's just set through ethics in this room. Are you comfortable saying anything at all? What do you have to advise these kids before you file the cases? And are they potentially exposed? You push the illegal envelopes, right?
Well, maybe Julia should answer that one too. Julia, do you want to respond to that?
It's been an interesting process. So the way that we've been connected with kids is through the I Matter campaign, and Al is his organization. So they know youth around the country. They bring youth to our Children's Trust. I connect them with lawyers. So it's been a process, and then once the lawyers are connected with the youth, they go over what the process is with the litigation. We have sort of a summary of what it means to be a plaintiff. The one issue of liability there is being cost shifting in different states if they lose the case. And so that's an interesting issue because we don't want these families to be subject to costs and fees. So what we've tried to do is our Children's Trust has tried to take that on, that responsibility. So we're helping fund litigation where we don't have pro bono attorneys. We're also saying, look, we're going to take care of the fee and cost shifting if it occurs. But we've been careful in terms of how we've brought cases. Lawyers have really looked carefully at those provisions in state law. In some cases, have only sought declaratory relief initially in order to specifically avoid fee shifting. There are most risky cases in Colorado, actually, and the court ruled in a way that avoided fee liability for us, which was great. So, but it is an issue, and attorneys have to advise their clients of that in the retainer agreement.
I might add to that. There's many youth who want to be engaged in this litigation who are not plaintiffs. And I think it's very important to engage those youth in the framework of this litigation. And one thing I think they could do is for non-plaintiff youth in a particular state to go directly to their governor or to their attorney general and say, why are you spending public tax dollars fighting your own children? And to bring the press to those conversations. Now, there does not need to be an all-out litigation fight over a remedy. What should happen in these cases is what happens in tribal fishing cases between tribes and states and many other cases, end up resulting in a consent decree. And that's where the judges determine the parameters, the sidewalls. But the state develops a plan to implement the remedy, comes back, and the plan is then worked into a judicial, ongoing jurisdictional framework so that it is enforceable over several decades. And that model is directly from the Indian Treaty Fishing Rights litigation of the Pacific Northwest. I think students can go to the governor and to the attorney general and say, why aren't you entering into a consent decree? That should be happening right here in Oregon. It should be happening in California. Any governor that wants to do anything on climate change will have to ensure that their initiatives can have that endurance quality. And we all know that there's no endurance in politics. So the only way for a governor to have any sort of climate legacy is to probably wrap it into some sort of judicial order within a constitutional framework. So I think that's how youth could be involved outside of the litigation.
Go ahead, yeah, in the purple, sure.
You said all hands on deck. My hands on deck.
Good.
My first specialty is public interest litigation to preserve subsidized housing. So would you rather I plant trees, or is there something else you'd like to help with? How would you like people, what do you want people to do?
Okay, I am so glad you stepped forward. You're doing public interest litigation on subsidized housing.
Repeater.
This, I am repeating.
And there are people who are going to do this thing.
So this attorney is saying, it's all hands on deck time. She put her hands here, she said, I'm ready to help. What do you want me to do? She doesn't happen to do environmental litigation. The first thing I would do is say, go to our children's trust, because this is unprecedented litigation as part of a huge campaign, and they are, I think, positioned to use as many attorneys as they can possibly use. So that would be my first recommendation. Our children's trust is on the website, but Julia Olson is back there. I personally think, no matter what Julia says, that an additional thing every attorney can do is to become a speaker for climate crisis and for the trust doctrine. So in your subsidized housing sort of hearings, I would, whatever you can do to educate people about climate and the trust, I would say do that as well. But I can't emphasize enough, this is a coordinated campaign, all hands on deck, in an orchestrated way through our children's trust. Thank you.
I have two sort of related questions because I'm interested in the defenses you're facing and the motions to dismiss.
Speak up.
The first is, it sounded like you said displacement, and it seems that that's not really appropriate because you're bringing state common law claims. They're arguing that the Federal Clean Air Act is displacing your state common law claims?
That a state Clean Air Act,
A state Clean Air Act is displacing.
or equivalent of state regulatory mechanisms that are there.
And you also described the way the judges are sort of issuing these rulings as, I don't have the capacity to do this. Are they invoking the political question doctrine?
I don't think there's been any explicit, because of the political question doctrine, but that's basically what they're getting at. They're saying, you're asking me to legislate, you're asking me to make a policy decision, and I'm not comfortable doing that. So that's basically what it's coming down to.
So they're not citing anything when they say that. They just say, there's no way I'm giving this.
They did say because it's such a novel approach, it's such a new idea, it's never been litigated before, they're scared of it. We're not talking about, a permit for a coal plant, we're not talking about any specific thing, we're just saying, overall, we're screwed, and state, you need to fix this mess that we're in. And without that concrete thing, it seems like they're just scared, they're not willing to take that leap and do what they have a duty to do under the doctrine.
And I want to get back on my favorite bandwagon about this myth of judicial activism, and it is having a profound effect, and let's be clear where it's coming from. It's coming from conservative think tanks that have an agenda that is playing out in real time. Judges are scared. They are being displaced from their former role, especially in states where judges are elected, which is now turning into campaigns that cost millions of dollars. And they are thinly veiled political challenges. And I think that part of our obligation is to change that culture and climate and give the judiciary the respect that it has been traditionally accorded in this country. And that's not something that we can solve in court, but I think it's a debate we have to engage in.
And then I'll just add to that, the obvious follow-up to that is that we only have 3 branches of government in this country. And the political branches have failed for years to address climate. And so it's worth reminding the judges, it's past the time that we can say the legislatures, can deal with this without some sort of judicial upper hand. We're past that time. And just constantly remind them, there's 3 branches of government, we've tried 2, you're a last resort. And we need that involvement.
One more comment. That argument about displacement is contingent upon the idea that the public trust doctrine is a common law doctrine, and it simply doesn't make sense to call it that. It's a constitutional doctrine, or it's no doctrine at all. And a constitutional doctrine isn't going to be displaced by legislative statutes.
Can you call it Andrew?
Yeah.
Andrew,